Right, but the Ambort thing came up in terms of the advantages of using a bar attorney as opposed to, pleading on your own behalf.
Oh, we were talking about the Wildcat moving.
Right, whether he had some high-priced legal talent working for him, which it appears that he did. I mean, it's a major sort of undertaking to have taken to a federal court.
Well, that's what I was wondering about the Institute for Justice, if they had been involved.
They very well may, because they, at the same time, as soon as the Wildcat guys, filed this lawsuit, the state filed charges against them for not having a license and tried to get them to stop, doing business.
Right, because they were moving people without a license.
Right. But
and somebody could have gotten hurt now.
There was no offense, there was no offense before he sued them.
Right, and nobody complained.
The only people who ever complain about this stuff are his competitors.
Right.
And in 5 years of history, not a single consumer complaint has ever been lodged with the state commission that's in charge of this stuff. It's always been, any protests or objections to issuing these certificates has always come from competitors, which is why this guy won in federal court.
Right.
The judge decided that the public safety really wasn't the issue here. The issue was just protecting his competitors.
Right.
From competition.
This is one of my big beefs about the government. They pass laws, so they're the lawmakers, and then they become the victims, and then they sue you, and then they act as the judge, and then they're the punishers. They put you in jail. Right.
There's a similar case that was where the plaintiff lost, and the judge said in the decision, he said, it's the prerogative of local and state governments to dispense economic privileges as they please.
Wow.
Yeah, I was kind of
right out loud. He said that
right out loud. He wrote it right in his decision.
Wow.
That's their prerogative, and we're going to let them do it.
Was that a federal judge?
It was a federal judge. Yeah. It was a very similar case that the other side used, to try and argue precedent.
Right.
But of course, it wasn't a precedential case. It was just it was in a district court case. Just like this case is not precedential either.
Right.
This, they can cite to this case for, to show that another court has found in favor of it, but they can't say you're bound by this precedent because it's not. It's not an appeals court.
So then somehow we got on.
We get on to the value of having bar attorneys is that they're simply taken more seriously. The example I was going to use was there's a criminal tax case that I'm aware of, an evasion case where the defendant has requested the what they call the source code. That's what he's asked for, the source code for the IRS IMF individual master file computers, and he wants to see this source code because he alleges that when the IRS creates substitutes for returns for individuals, such as they did in this guy's case, that they have to maneuver around software safeguards that are built into the system.
Right.
Because they're really not allowed to create Forms 1040. There's a number of business forms that they are allowed to create, but Form 1040 is not among them, which is the basic individual tax return form. And so Mr. Bailey, who's the defendant in this case, claims that they are indeed maneuvering around software safeguards that are built into the system. And in order to prove his case and in order to defend himself against these charges, he needs access to the source code, to the computer.
Like the software source code.
The software source code of the computer to see if it is indeed programmed to block the creation of Form 1040 substitutes for return. And he suspects it is. I suspect it is too. And the government has resisted mightily his discovery requests.
The IRS has resisted a discovery request?
Imagine that.
Imagine that.
But, so they've resisted that. And the point I was going to make before was that Bailey has hung these people up. He's been in litigation concerning his criminal case for over 2 years. And it's likely to go on for at least another year as they wrangle over this discovery. Whereas the identical discovery motion that was submitted by a pro se in a similar criminal case was dismissed out of hand without comment. And that guy's already in jail. Because he didn't present his discovery through the offices of a bar attorney.
Right.
And you're just treated differently. There's no getting around it.
So that's the value of having.
That's the value of having an attorney.
That we are Do we pay every month?
Oh, we pay. We have criminal defense insurance with the Free Enterprise Society.
And what's that attorney's name?
Larry Becraft.
Right, Larry Becraft.
And Becraft has some impressive wins.
Mm-hmm.
Although Becraft, as most tax attorneys, his losses far outnumber his wins.
Well, as most tax attorneys who represent tax honesty people.
Right.
Right.
Exactly. Or even tax attorneys that represent anybody. They have a winning record.
Yeah.
The government has wins much more often than they lose. Because
the judges on their team.
Because they stack the juries and the judges on their team, and they control the flow of evidence to the jury.
Right. And that's the big thing.
Yeah.
That was something that I wrote on Thomas Massey's wall, is that the judges routinely deny the taxpayers' evidence,
right,
and allows everything.
Everything the government presents is relevant. Everything is,
And I've heard this for CPS court.
It's exactly how it works.
Yeah, exactly how it works.
CPS
are not allowed to present their evidence.
Yeah, you control the evidence, you control the outcome.
Right.
The jury only gets to hear one side of the story.
Right.
And the jury's in no position to know that they're being bamboozled or manipulated. They just don't know.
Right. Yeah. I mean, you hear all the time people come out of a jury and they say, if we'd known all this, we would have ruled differently.
Right. Yeah. If the judge told us we had to rule according to his instructions on the law.
Exactly.
They broke the law. Boom.
Yeah.
Because the judge doesn't inform you that you are entitled, as a juror, to decide both the law and the facts, to decide the justice of it. Even if you know he broke the law, you're perfectly justified in saying no, he's not guilty.
Right.
But
because you can judge the law.
The great majority of jurors do not know that. If you inform the court early on that you do know that, you will not be selected as a juror.
Right.
Simple formula there.
Clever, what?
Clever, yeah.
Yeah. So Glenn Ambort, what is Glenn Ambort? Oh, Glenn submitted
Glenn Ambort is not an attorney.
Mm-hmm.
He's a longtime tax honesty advocate. He spent 9 years in jail because of his beliefs. He was
that thing just breaks my heart.
Railroaded into jail.
Mm-hmm.
And
who was his friend, Benson?
His name was John Benson. He's dead now. He died last July. And they've done a great deal of research on the history of tax administration in the United States and how it relates and how it grew out of the practices that were common in the British Exchequer Court in the 18th century, which is what the British Crown uses to collect his taxes, to collect the king's taxes. Mm-hmm. And their research is very scholarly, very revealing, and the main thing to come out of it is that the Form 1040, the modern individual income tax return, is a species of what was called a statute staple contract, and it's a very peculiar technical sort of type of contract that was available to merchants in England when they were dealing with foreigners, because the foreigners could just leave the country and be out of reach, after ripping off an English merchant. Mm-hmm. So statute staple contracts were set up to protect basically domestic merchants against any predations and hanky panky by foreign merchants.
A statute staple contract would follow them across the pond.
Well, but what happens is that they can be bound by this contract essentially with only one signature. They don't necessarily have to sign, and and if they do sign it, the other side doesn't have to sign. When you sign a statute staple contract, what you're saying is, I agree to this obligation, and the other side doesn't have to sign the contract, as with most contracts.
Right.
And that's what distinguishes a statute staple. It's a commercial sort of contract. And those among the two methods that the king had back in pre-revolutionary days for collecting his taxes, the first was through what they call a board of inquiry. And that would be pretty much the equivalent of a tax court case or something, right? Where they look into the facts and the court rules and determines the tax that's owed, and then certifies. In other words, somebody swears that you owe the money, and then it goes on to the record, and you owe it. The statute staple contract, however, is a voluntary acceptance of liability. Right. The word voluntary rings throughout the code, and in fact, if Ambort and Benson's research is accurate, which I believe it is, this is the Form 1040 is indeed a form of statute staple contract.
Well, and they have that famous recording. I think it's Harry Reid saying taxes are voluntary, and that's always been. It's true. They are voluntary. They're supposed to be voluntary.
And the other reason that they must be voluntary is that affidavits, which are sworn statements of fact, affidavits must be voluntarily given in order to be valid.
And a Form 1040
is clearly
an affidavit.
An affidavit, right? It's a statement of facts with your signature under oath at the bottom of it. It's an affidavit. It's the classic affidavit.
So you have to only sign those voluntarily, or it's not, or it's void.
It's void and invalid. That's correct. You cannot be coerced into signing an affidavit.
Right.
You also cannot be coerced into giving up any right. So when you sign a 1040 tax return, you are waiving your right against testifying against yourself. The Fifth Amendment protects you from self-incrimination.
Right.
And in order to sign a Form 1040, and it's absolutely acknowledged throughout the legal community, you must waive your right against self-incrimination.
So the 1040, when you sign it under penalties of perjury, you're agreeing that you owe the money, voluntarily agreeing that you owe the money.
Absolutely.
So if the IRS comes in and says, you have to sign that, it's a law, you have to sign that. You have to tell me everything, you have to sign that. That right there on its face it negates the whole thing.
Exactly. It voids the entire affidavit.
Has anyone ever tried to push the IRS on that point?
As a matter of fact, there was an interesting case in the 10th Circuit by a man named Conklin. And Conklin took a case, prepaid his taxes, didn't sign a Form 1040, took the case to the appeals court. I'm a little sketchy on the details. We should talk about this in a separate thing.
Okay.
But essentially, after sitting on his case for 5 years, his question was, can I sign this without waiving my Fifth Amendment rights? The court was between a rock and a hard place. They knew that they couldn't say yes. This is, you must sign this under penalties of perjury, no matter what. And so after 5 years of letting it sit, they finally ruled that no, it's not coerced testimony. Is how the court ruled.
So they can force you to sign it, and then they're calling it not coerced.
No, well, the appeals court in the 10th Circuit said it is not coerced. You do not have to sign one.
You do not have to sign
right. And it's been kept understandably quiet.
Right.
You can go to Bill Conklin's website and read all about it. He'll have the details. But the whole voluntary, compelled thing. There are many signs that it is indeed voluntary.
Right.
And,
doesn't it say it in the code somewhere?
Well, it says that it's based on voluntary compliance. But there's a lot of wordplay and hanky panky that goes into the actual explanations of what your obligations are.
So how long is that guy in jail? The Glenn Ambort guy, the guy who...
I don't know. I think he got 16 or 18 months. He got off pretty easy, frankly. They had him for like 3 years of evasion, 3 years of failure to file, willful failure to file, they called it. And he was a Hendrickson devotee who gave up filing Hendrickson's way. And that's when they jumped on him. Because now, once you undertake a path and claim, oh, this is what I believe is true, and then later on you change your mind, you've done something very, very dangerous, by saying, by trying to renounce previous sworn testimony. Right. Then they can accuse you, well, why didn't you keep doing that if you thought that was true, And that was the trap that he fell into.
Right.
That he didn't stick with it. Once you've made these decisions and signed things under penalty of perjury, you pretty much got to remain consistent in order to remain.
Or really cover your ass if you're going to change your.
Yeah.
Because we learn stuff, and you and I,
stuff, right.
We've certainly learned a lot along the way.
Yeah.
And changed our MO.
But one of the approaches the court takes to people who have learned the truth about the tax is that, well, for years you signed tax returns. What's all that about? And now suddenly you've changed your mind. They don't want to believe that you can possibly learn something new that would convince you that you had been making mistakes. Well, because they don't want to admit that you can learn something new.
They don't want to admit, of course. So, and I'm particularly fascinated by the whole statute staple contract thing, that we are using a form that is basically brought over from the king's tax.
Yeah, there was a case in 1856 called Murray's Lessee against the Hoboken Land and Improvement Company or something like that. But it was a case where the court discussed in great detail the history of administrative tax summary administrative procedures.
Mm-hmm.
And the court did this research. The court did all this research into the British law and British practice at that time in the Court of the Exchequer, which was the court where the king collected his taxes.
The Court of the Exchequer.
And the court, in the Murray's Lessee Court, the Supreme Court, did all this research, and it's in that case. And it's not an easy read.
No,
by any means. It is not an easy read, but it is not impenetrable either.
Mm-hmm.
And they refer to, the great English jurists, Blackstone, Chitty, West, all of these guys who wrote about English common law. They are all referenced in this case. The court, came up with this explanation, and at the time there was nothing to hide. At the time the income tax didn't even exist in 1856 when this was done. So what they were talking about is just general summary administrative collection procedures and how they work. So it's not tainted by anything that had to be hidden.
Right.
It was only later that this Murray's Lessee case becomes pertinent.
After 1913.
After 1913, after 1862. 1862 was the passage of the first income tax.
Right.
And it was clearly, and it's still on the books, and it is still the basis of today's income tax. The language has changed almost not at all. Mm-hmm. But the early language was crystal clear that it applied to government employees and government contractors and those who were receiving some sort of payment
federal
from the
privilege.
Government. But it absolutely never applied to the working man.
Right.
The feds knew better at the time. They knew that they couldn't reach into a working man's pocket without apportionment. They knew they could do it, and there are instances of direct taxes that were passed by Congress, but there's only been 6 or 8 occasions.
Right. It's got to be for a specific amount. It's apportioned among the states according to population,
exactly
which is why we do a census.
Right.
For that and for the representatives.
That's correct.
And then it has to have an end date.
Right. Once they collect the amount,
an end date.
And the bill goes to the states.
Right.
The feds are billing the state.
Right.
The state goes after the money.
Right.
And the state can collect the money any way it wants. It's basically a direct tax is a head tax. So what they do is they notify every citizen, you owe this much in head tax. Mm-hmm. Send it in.
And in those days, if the citizen didn't send it in or couldn't send it in, I guess you went to debtor's prison?
No, you didn't. They had tax collection procedures in place. There were, in those days, tax collection was a hired job. You were given a commission as a federal officer, but you were paid as a commission of, you were paid as a portion of what you collected.
Oh, you're on commission, like a salesperson.
Straight commission. They didn't
like
pay
a bounty hunter.
Like a bounty hunter, exactly. And you were paid, a reason. It was not a big commission, by any means. It was a small percentage.
Right, but just like, real estate sales, 3% was good.
Yeah, these guys were frequently targets of protest. There were old engravings of, patriots tarring and feathering tax collectors. Not that I'm suggesting anything like that should occur.
No, we wouldn't want to tar and feather anybody, would we?
No, we wouldn't. Feathers are so hard to find these days.
We needed to collect them from when we process our broilers.
Use packaging peanuts or something. I think it might be
right.
practical.
Conversations with Lysander. If you have a question or a situation or a comment for Lysander, please go to patriotrescue.com and click on the speak pipe icon in the right sidebar. Leave us your question or comment, and we'll discuss it on one of the next podcasts. Thank you so much. Bye-bye.